All right, this is an application?
It is for deferred.
All right.
Right out of the gate, we've got Jason Bustos in front of Judge Boyd on a serious aggravated assault with a deadly weapon charge. This isn't a slap on the wrist case. The stakes here are years in prison. And just wait until you hear what led up to this road rage nightmare.
Court is calling 2024 CR 6690, State of Texas versus Jason Bustos. Could I have parties announced for the record for the state?
Galloway for the state.
Ron Ross for defense.
And are you Mr. Bustos?
Yes, ma'am.
Did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on an indictment as presented?
Wish to waive and abandon count 2 and proceed on count 1.
Any objection?
No objections, Judge.
Are you proceeding with a deadly weapon or waiving that as well? Okay. All right. Did you review the document entitled Court Admonishments and Defendant's Waivers with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with aggravated assault with a deadly weapon? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea you were giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand that the court were to grant your application for deferred adjudication if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Bustos, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 1. Punishments be assessed at 6 years in the prison. All right, let's go off the record.
Here's the key legal twist. The deadly weapon finding this isn't just a label in Texas. That finding changes everything. It means Jason won't be eligible for certain types of early release, and it will follow him long after the sentence is served.
States you're opposed to deferred?
Yes.
Okay. All right.
Because he's not eligible for community supervision. So
So,
I did it wrong on the paper.
no. I mean, this is an affirmative finding of deadly weapon. So if y'all could just check that for me.
Okay.
All right. So, Mr. Bustos, as part of your plea bargain agreement, the state is proceeding with a deadly weapon allegation. You're charged with you're charged with aggravated assault with a deadly weapon. So if from reading the stipulations that may be accepted into the record, if I find that a weapon is used, then there will be an affirmative finding of deadly weapon. Do you understand?
Yes, Your Honor.
The state is opposed to your application for deferred adjudication. So according to your plea bargain agreement, if I don't grant your application for deferred adjudication, the most time I could sentence you to would be 6 years in the prison. Do you understand?
Yes, Your Honor.
All right. And the other thing they're asking for is they're asking for restitution to the complainant, and they're asking for a $2,000 fine. Did you understand that to be the entirety of your plea bargain agreement? Defense, is that the plea?
It is, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Okay. And outside the agreement, the state is requesting no contact with the complainant. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right. State any evidence.
State offers state's exhibit number 1 and attachments.
And defense has no objections.
All right, state, you may be excused. Did you review the stipulations with your attorney? Did you understand it and cite it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state would call in the right to remain silent.
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you requesting a PSI?
We are, Judge.
All right. Is there a need for a TAP evaluation?
I don't think there's a need, but
All right, we'll do a TAP evaluation. Mr. Bustos, is there any mental health issues?
No, Your Honor.
All right. So, Ms. Ferguson, PSI and TAP evaluation. And probation, this will be PSI and TAP. And counsel, I'm sorry, I need the trial court certification back. Thank you. All right, March 3rd, counsel?
that's fine.
Okay. All right, do you have any questions?
No, Your Honor.
All right, then you will be excused. Probation will come visit you. And are you Jason Giovanni Bustos?
Yes, Your Honor.
All right, you entered a plea on January 13th to count 1 guilty. The state waived count 2 without objection. You applied for deferred adjudication. According to the plea bargain agreement,
Jason admits he actually shot at another driver. Think about that for a second. In a moment of road rage, a simple traffic dispute turned into a potentially deadly encounter. Would you ever pull a gun over someone cutting you off? Let me know in the comments.
punishment is to be assessed at 6 years in the prison. There's a $2,000 fine. There's an affirmative finding of deadly weapon. The state opposes your application for deferred adjudication, and there's to be restitution and no contact to the complainant.
Jason, you admitted when you were here, you admitted to probation that you shot your gun at this other person, correct?
Yes.
And this had to do with on a road, you and another vehicle were playing jockey back and forth, correct?
Yes.
And I want to make sure the other vehicle was a F-150 Ford pickup.
Yes.
And you had a 95 Ford Ranger, correct?
Yes.
4-speed.
Yes.
And you felt threatened by, is that what you assumed, where you felt threatened by the actions of the other driver?
Yes.
You know now, when you carry guns, things like this can happen. You can overreact. You understand that that's not very smart. Right?
Yes.
That's not a smart thing. You overreacted.
Yes.
Have you learned a lesson?
I did.
Any other questions? All right, so this
I may
is,
just say this one thing,
yes.
if I may.
Well, just 1 second, because I want something cleared up for me. In the report, I'm reading the synopsis, and this is what the synopsis says in the stipulations. It says that the complainant was in his personally owned vehicle. The suspect was in his vehicle, and the suspect began to brake check him on the interstate. I understand brake checking people because sometimes people are riding your bumper. I understand that. I think it's crazy to do that, but I understand why people brake check, say, hey, quit riding my bumper. So that's not the problem for the court, that you were brake checking him. It says that the complainant decided to pass you and continue on his way. So what the synopsis so far is saying is that you were brake checking him, I guess because he was riding his bumper. And then the complainant decides, you know what, I'm just going to pass this guy. So it says that he passes you, then you caught up to him, pulled up next to him, didn't fire your weapon, but exhibited your weapon to him, and then got in front of the complainant and started brake checking him again. That's where I have a problem. I can understand you're driving. Maybe the speed limit is 60. Sometimes people will be in what's called the fast lane on the freeway, and they're going below the speed limit, which is a no-no. But let's say the speed limit is 60, you're going 50 or 55, who cares? You're going less than whatever. Or maybe this person is speeding behind you. So they're behind you, they're riding your bumper, which people do, which they shouldn't do, because that doesn't give you time to stop if you need to stop immediately. So this person says, you start brake checking them. So I'm sure tempers are high.
This is where Judge Boyd lays out the real danger. When bullets fly, you don't control where they land. It's not just about the target. A stray shot could hit a child in the back seat or cause a crash that kills an innocent driver. That's why courts hammer these cases so hard.
His temper is high. I know the complainant was probably upset, probably said a few choice words. And then the complainant gets from behind you because you're brake checking him and speeds past you. Maybe he gestured towards you or whatever, but he doesn't pull a weapon. So he speeds past you. That should have been the end of it. Maybe you get on the phone. You say you didn't have your phone, but maybe you memorize his license plate and call the police and say this person is recklessly driving. But he says what happens is you don't do that. After you brake check him and he decides to pass you, you then catch up to him and exhibit your weapon. That's a no-no right there. And then it says, then the complainant, instead of him just calling the police after you pulled your weapon at him, he pulls out his phone to start videotaping you. And then what he does, after you pulled out your gun and exhibited at him, he starts filming you on his phone. And then he starts chasing after you in his vehicle to film you. And it says he continues to follow you. And then they both took the turnaround at Bernie Stage Road and went on the access road. And it says that the complainant then continued to record you. And then you both got off at the 20,000 block of Interstate Highway 10. And then you came to abrupt stop as the complainant passed you on the left. And then when he passed you on the left, it says you started firing with your automatic handgun. And it says that the complainant was still filming on his cell phone when this occurred. So is somebody saying those are not the facts? Because that's what I'm reading.
The last part, Your Honor, from what I can remember, is he did not pass me up. He just stopped after I stopped.
Mm-hmm.
I stopped just to make sure he can continue going.
So did you brandish your weapon more than once? Did you brandish your weapon at him first and then brandished it later throughout this incident and then shoot it?
I brandished it once,
And when you brandished it, you fired it.
only on the second time.
Okay, so then you brandished it more than one time. What the synopsis is saying, and don't feel that you have to agree with me. I'm just saying what's in the synopsis. What the synopsis is saying is you brake checked him. And then after you brake checked him, he went around you and past you. You brandished a weapon. You didn't fire it. He gets upset that you're brandishing a weapon. So then he starts following you and filming you. And then you all meet up and you fire bullets into his vehicle. So is that not true? Is that not what happened?
Yes, Your Honor, that is what happened.
All right. If it's not what happened, just tell me. I'm here trying to figure out what the appropriate sentence is. But I do have a problem if you're brandishing a weapon at somebody, right? And then later you brandished it again. There's a gap in time for tempers to cool. And then you brandished it again and you fire into a vehicle. Did you know how many people were in that vehicle? What if there were children in that vehicle? In their car seats, because you really can't see when babies are in car seats. People could have been killed. And then if you would have been a good shot and you would have killed him, maybe he would have crashed in other vehicles and somebody else would be dead. So you wanted to say something, counsel, or is there any other questions for him?
No, just something, an argument.
Sure.
Two things. One is 95 Ford Ranger, my wife, although she drives a new car, has a 96 Ford Ranger, six-cylinder. She uses for hauling plants, shrubbery, rocks, dirt. Ford Ranger does not have a lot of pickup. Well, it has a limited speed it will go. An F-150, it doesn't have a lot of acceleration. An F-150 has got a lot of acceleration. So we've got a small car and a large car. I don't know what happened, but I'm saying there's a difference there. And the 150 ought not be picking on the smaller guy, if in fact that was what he was doing. Second off is his questions about why don't you call the police. I don't want my wife going down H10 and getting off on the service road going at 50 and 60 miles an hour, getting on a cell phone and making a phone call.
Oh, well, what I can tell you, counsel, the whole thing about calling the police, that's not the big issue for the court.
Oh, I know.
Yeah, okay.
And I think he understands what he made a mistake. Also, I think he's had some mental health issues. He took medicine. They got him back on medicines in the jail. He has no prior criminal record. He had a job. He was productive before this happened. There's nothing in the record that says this would be a reoccurring type thing that I can see.
Despite the defense's plea for probation, Judge Boyd isn't buying it. She sees a man who escalated not once, but twice. And that second time it ended with live gunfire on a public road. The sentencing is about to drop.
Once he's learned a lesson, give him a chance on probation. I'm asking the court to give him a chance on probation.
All right. Is there any objection to the restitution of $250 to the complainant for his deductible?
No, Your Honor.
All right, the court is going to find you guilty. The court will sentence you to a $2,000 fine, time and money to run concurrent. There's an affirmative finding of deadly weapon.
4 years in prison, a deadly weapon finding, no contact with the victim, and restitution. Judge Boyd's message is crystal clear. Anger behind the wheel plus a gun equals prison. This is a textbook example of how a few bad decisions can change your life forever.
I'll ask for the therapeutic community based on the mental health. And I do understand, based from reading the synopsis, what was going on with both parties. And there was bad behavior on both sides. But Mr. Giovanni, this is not a probation case. So what I'm going to do is I'm going to sentence you to 4 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. There's to be no contact with the complainant, and $250 of restitution to the complainant. All right, we can go off the record. So I gave you something less than what the state requested because of the facts of your case. You're going to have to get a control of your anger, and you have to start making better decisions. A gun should not be the answer to every issue that comes up. All right, good luck to you.
And he gets credit for time served, right?
Yes.
So you go. It's a fair thing to do.
An arrest is made in a separate road rage investigation. This one happened on I-10. On Saturday, Jason Giovanni Bustos was charged with aggravated assault with a deadly weapon. KENS 5 reporter Simone Simpson has been digging into this story all day and joins us live. Simone?
ECs. According to the affidavit, the victim used his phone to record what happened. After being brake checked, the victim passed Bustos. Then Bustos caught up with him and showed him a gun. Moments later, police say Bustos started shooting. Aggressive driving in Texas is not unusual, but there is technology and development that aims to keep you and your family safe.
We discovered there was 1,015,001 citations issued for speeding in excess of 15 miles per hour.
That's according to a 2023 study across 5 metropolitan Texas cities, including San Antonio.
We're the only program in the country that is looking at the causation of the behavior, not the outcome of the behavior.
Dean DeSoto is the executive director of Community Alliance Traffic Safety, Inc., a charity that is leading the charge against aggressive driving with a simulator. It runs off a laptop, has a steering wheel, accelerator, and brake, and has 3 screens that place you in the simulation of a vehicle.
It's interactive. It uses AI, so in that it learns your behaviors very quickly, and also the information will be programmed in as a so whatever how you respond to our knowledge and attitude will be programming that into the simulator.
DeSoto is hopeful that this technology can elevate the topic of aggressive driving amongst current and future drivers.
This is not a driving safety program, it's an attitudinal program. And it's what I call an intervention and prevention program.
He feels the culture of driving is the problem.
We seem to be driving faster, and we're less compassionate, and we're more willing to take a life, which just strikes me as very strange behavior.
And the prototype for the aggressive driving simulator is expected to be completed by June this year. As for Jason Bustos, he is set for pre-hearing April 10th at the 187th Criminal District Court. His bond is set at $100,000. We are still waiting on SAPD to let us know if the victim in this case was hurt. Reporting live from the studio, Simone Simpson, KENS 5.
Simone.